Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We welcome those who join us on all of these occasions on our heritage.org website. Would ask everyone here in-house to be so kind to check that cell phones have been turned off. And our internet viewers, of course, are always welcome to send questions or comments, simply emailing us at speaker@heritage.org. And we will post the program within 24 hours on our webpage for everyone's future reference. Hosting our event today on behalf of the Margaret Thatcher Center for Freedom is Stephen Groves. Mr. Groves serves as our Bernard and Barbara Lomas Senior Research Fellow in the Margaret Thatcher Center. Please join me in welcoming Steve. Steve?
Good afternoon, folks. Thanks everyone for coming to Heritage today. I'm really happy to host this panel today on this treaty, the Arms Trade Treaty, and for that matter, probably for almost all the treaties out there. You can find panels of pro-treaty people, usually all around Washington and in Geneva, New York. Rarely do you have a chance to have an entire panel of people who aren't 100% behind the treaty, people who are maybe skeptical of the treaty and what it means for American policy, what it means for American sovereignty. So that's what you'll be treated to today. A panel of people who've taken a hard look at the Arms Trade Treaty. Now, in order to relieve the panelists of the burden of going through the prior proceedings of the ATT, and just they can leap right into where we are today, they've asked me just to give a brief history of the ATT and where we are up to. And so it came into being, the treaty did, on April 2 of this year. But the process for starting it began as many strange multilateral treaties began back in the 1990s, driven by non-governmental organizations. This was a classic pattern during the 1990s where NGOs and not nation states were the driving force behind a series of wrong-headed treaties, and the ATT is part of that family. This process is part of the new kind of international diplomacy that we have many concerns about here at Heritage because of its implications for American sovereignty in general, and the role of international diplomacy. In July 2012, after a series of PrepComs, the first UN conference on the ATT was held and it failed. And in March 2013, earlier this year, there was a second conference that also failed to reach consensus, which was a very important aspect of it because one of the Obama administration's red lines was that it would not join the document unless there was consensus. Consensus is important. That means all the countries who deal in arms are on board. And so they drew a negotiating red line that they wouldn't join unless there was consensus. Of course, we saw that red line go the way of other Obama administration red lines because when the conference failed, they went on to the conference room next door to the UN General Assembly where the treaty was voted on and properly adopted. So another red line that's being ignored once laid down. So not only did we cross that red line, did the administration cross that red line, they jumped over with both feet because they were a co-sponsor on the resolution at the General Assembly. So it came into being. And the Secretary of State has announced that pending the satisfactory completion of the ATT to be translated into the official UN languages, the U.S. will indeed sign. And that event may be coming up very quickly because the President will be speaking to the UN General Assembly probably on September 24, and there is a UN treaty event on the ATT at the General Assembly building to be held on September 25. So the U.S. is likely to sign around that time, and if not, very soon thereafter. Now, there's already been a great deal of skepticism about this treaty up on the Hill. There have been a series of letters with many, many signatories on them, led by Senator Jerry Moran of Kansas and Congressman Mike Kelly of Pennsylvania. And then most recently, a concurrent resolution has been introduced in both houses with 35 bipartisan co-sponsors in the Senate and 148 in the House, raising grave concerns about the United States membership in this treaty. And if and when the President does sign this, that skepticism can only grow. And today we're going to examine the treaty through our four panelists. And a lot of the comment in the press is focused on the Second Amendment questions, and there are questions there, but all of the concerns about this treaty should be covered during this panel. And we'll touch on some fundamental basic questions on sovereignty, what treaties we should enter into as a country, and what treaties we shouldn't. We have distinguished panelists with us, and I'll give you a brief biography of each, also to relieve them of telling you who they are. Leading off, we've got Major General Alan Youngman. He's a native of Owensboro, Kentucky. General Youngman holds his J.D. from the University of Kentucky and is a recognized expert in the fields of national security operations and U.S. Armed Forces policy. His significant active duty assignments included tours with the 8th Special Forces Group, the Military Assistance Command Vietnam, and the 101st Airborne. I'm sure you've heard of some of those organizations. He retired in 2003 with more than 34 years in the service. Today, General Youngman is the Executive Director of the Defense Small Arms Advisory Council. It's a nonprofit formed in 2004 to represent the interests of the defense-related small arms industry in the U.S., and he has been responsible for presenting the Council's position to the UN throughout the ATT process. Second is Johanna Reeves. She received her J.D. from the University of Miami Law School in 1999. Congratulations on your victory over the Gators. I join you in that, being a Seminole myself. She is a founding partner at Reeves and Dola, where her practice for the past 10 years is focused on regulatory compliance under U.S. export controls and federal firearms laws and regulations. She also serves as the executive director of the Firearms Import-Export Roundtable Trade Group, a national nonprofit membership organization dedicated to promoting and protecting the interests of the firearms and ammunition import and export community. Third, although I think we're going slightly out of order, is Dave Coppell. Professor Coppell is the research director of the Independence Institute and adjunct professor of advanced constitutional law at Denver University's College of Law. He received his J.D. from the University of Michigan Law School and is the former Assistant Attorney General of the state of Colorado. He's published widely on many subjects and is an acknowledged authority on the Second Amendment and gun control in the United States, throughout the UN system, and around the world. He is a co-author of Firearms Law and the Second Amendment, published in 2012, the first law school textbook on the Second Amendment. And I hope that law schools around the country begin a course in Second Amendment and gun control law. With other co-authors, he's written extensively on the history of the natural right of self-defense and the effects of gun control and gun confiscation programs around the world. And finally, wrapping up is my Thatcher Center colleague, Ted Bromond. Dr. Bromond received his PhD in 1999 from Yale, where he then worked and taught for more than a decade in international security studies. In 2008, he moved here to the Heritage Foundation, where he's worked in the Thatcher Center for the past 5 years, currently as the Senior Research Fellow in Anglo-American Relations, where he has written extensively on the Arms Trade Treaty and related UN and regional institutions and treaties. And he has, and this is where he really did his hard work and mind-numbing work, attended both of the UN's ATT negotiating conferences. And if you've ever been present at a UN negotiating conference, you know of what I speak. Each will give a statement, and we hopefully do some Q&A from the audience. Please join me in welcoming our panel today. And General Youngman, will you please start us off?
Okay, thanks, Steve, and thanks, Ted and the Heritage Foundation for organizing this event. DSAC, as Steve mentioned, is a trade association. We're made up of most of the U.S.-based military small arms manufacturers. We started getting involved at the UN around 2006 because there seemed to be so many things going on there. And while a lot of interests were well represented, we felt like our share of the market is so unique that we probably needed to get engaged and have an idea what's going on and be in a position to offer assistance where it was sought. And as Steve said, the ATT idea was planted a long time ago. its advertised purpose, of course, was to require all state parties to adopt some form of export and import regulations for military arms. Military arms initially defined as tanks, fighter aircraft, combatant Navy vessels, artillery systems, and things like that. But there was kind of this unspoken assumption that at some point, small arms and light weapons would be added to the list of what they call the Conventional Arms Registry. In reality, some 99+% of the dialogue and emotion was about small arms. And I should mention, we got several members of the delegation, combat veterans from the Indonesia Lounge and places like that at the UN. Ann Ganser, Bill Malzahn, Bill Coleman from ATF, and I'll talk more about them in deeply personal terms in a few minutes, to ensure that they stay awake during this presentation. But I think in all the sessions we went to from 2006 on, I think I heard something other than small arms mentioned one time, and that was reference to military trucks, and I think it was just kind of a throwaway comment. Everything else was about small arms. And there's a couple of reasons for that. One is you read very little about an out-of-control black market of nuclear submarines. I mean, they're pretty well controlled. And also the larger defense systems, I think because the companies that produce them tend to be so large and multinational, I think their interaction with the treaty process was either in private or because so many of them are represented in European delegations, not much was said about the larger systems, but a lot was said about small arms. For a number of years, the U.S. had said we and other nations have said we don't really understand why we need an arms trade treaty. If the outcome, our dream outcome is everybody in the world goes home and adopts regulations and enforces regulations and legislation concerning export-import related activities in the arms trade. I think it was the Russian delegate at one point says, why don't we all just go home and write those regulations? If a country that's inclined to do so doesn't need a treaty, signing a treaty is not going to provide any more impetus to do so. And right now, only about 25% of the nations on Earth have anything resembling export-import regulations. But it became obvious at some point around 2008 that there was going to be a treaty. And the U.S. continuing to vote against going to a negotiation with its only reliable ally being Zimbabwe. I mean, this was not a viable position for the U.S. going forward. And I think they made the right strategic call that if we wanted to influence the content of the treaty, we needed to be part of the process. And I think that was a good call. For reasons I'll try to demonstrate in a minute. The U.S. red lines were important. They're still on the website, I think. Steve mentioned the first one. It's got to be on the basis of consensus. The second was that it in no way interfere with the Second Amendment. And the exact language is an ATT will only address international transfers of arms and will not prohibit or address the internal transfers of states. And we'll come back to that in just a minute. VSAC's position going in is that we are already subject, not subjected, that sounds a little different, to the most rigorous export licensing system in the world, to the extent that we're frequently at a competitive disadvantage in the global market with manufacturers residing in countries that don't have anything like as rigorous an export control system. So our thinking was that, well, if the outcome of the treaty is that it actually raises the standards for our competitors, if they have to go through anything like what we have to go through, that could be a good thing. And as I frequently said during presentations at the UN, we would like for our competitors in foreign countries to enjoy the same peace of mind that we do before we export military firearms. One of our main concerns was that the treaty would include language that would be inimical to civilian firearms ownership in this country. And the reason that that's important to us, first of all, there are a number of organizations that, we are not a civil rights organization. The National Rifle Association, the Second Amendment Foundation, Alan Gottlieb and Julianne Versneller in the back there. I'll segue into saying, if if the UN process accomplished nothing else, it helped us build a really good network of people who work this issue. Gun Owners America, I think, has had some role. But from our perspective, just a very narrow business perspective, we had two reasons we had to keep track of that issue. One is all of our members are in both markets. Military sales are not dependable enough, predictable enough for companies to stay in business. Particularly for component suppliers, that's the case. So we're in the civilian market as well, particularly since we have trouble competing sometimes in the overseas market. But the second reason was, if a treaty actually emerged that showed some promise for raising standards worldwide for exports, we thought it would be nice to have a treaty that the United States Senate could conceivably someday ratify. We recognized that if there were questions raised about the Second Amendment implications, that was not going to happen. Some of our more specific concerns were that language would make it into the treaty that would change the internal commercial situation in this country. For example, the governor of Mexico was very, very adamant, very hard over in trying to get language into the treaty, for example, defining transfer in such a way that it could apply to things that happened entirely domestically. In fact, they were successful in the spring of 2012. The draft language with which the July month-long negotiations conference began last summer defined the scope as follows. The treaty shall apply to all international transfers of conventional arms. That's not too bad. And then they defined transfer. Two definitions. One was the physical movement of arms into or from a national territory, and which includes the transfer of title or control over those arms. We could probably live with that. That sounds like export and import, right? But then the government of Mexico was able to insert another clause that says, or the transfer of title or control over those arms. Now, obviously, if the preceding paragraph required physical movement into or out of territory, this one did not. So any change in title or possession would have been under the scope of the treaty. We had a real problem with that. Had this been successful, we feel like it would have set up a direct legal assault on the Protection of Lawful Commerce and Arms Act of 2005, which, as you know, at that point in time, a great many arms companies were, under severe attack. The people bringing the lawsuits rarely won anything, but the cost of defending those lawsuits was ruinous. So Congress said, look, we're going to, prohibit such lawsuits in the future. Our concern was that language like I just described a few minutes ago, combined with a presidential signature, which would then trigger some arguable obligation to adhere to the object and purpose of the treaty, would set us up for being right back in court. So we were very concerned about that. And if it sounds far-fetched, you need to know that the Mexican government, in fact, retained a law firm in New York in 2010 for the specific purpose of mounting collateral attacks on the Protection of Lawful Commerce and Arms Act of 2005. We were very concerned about it. The good news is when I went running with my hair on fire to the U.S. delegation and said, "We're going to do about it," we got it. We already know about that. We're already on top of it, and sure enough, that language disappeared, and it did not make it into the final text. I'll let Dave Koppel address some of the Second Amendment issues. There's still, I think, a lot wrong with the current text of the treaty. It goes not so much to the things that are bad, but if we understand that the outcome of the treaty is probably not going to change anything on the ground in a lot of places where there's so much armed violence, so much instability, because the problem there is not the arms trade. The Victor Boot Airlines model is not the factor. The factor is perfectly legal sales from major producers of arms to weak governments in exchange for market access, raw material, concessions, things like that. That's what causes those arms to flow. And then once they're in that particular country, whether or not a treaty of any kind is going to prevent future retransfers, re-exports to regimes or countries that shouldn't have them, it's kind of a stretch to see the Arms Trade Treaty having a direct impact on that. The other thing we have I think a lot of people are concerned about is the language of the treaty is ambiguous. In fact, at the Stimson Center event several weeks ago, Tom Countryman, who was the head of our delegation, referred to it as ambiguity, and Rachel Stoll, who helped to draft the treaty, said, she corrected and said, no, it's creative ambiguity, and I think that's a good description of the treaty, and that can be good. It can also lead us in a different direction. The only way the treaty gets implemented is through national legislation, national regulations. Every country that signs it then says, here's what we think the treaty means and requires. A lot of the NGOs that helped push the process forward, as Steve mentioned, are the ones, they're sitting there right now, next to those national governments, helping them come up with the legislation or the directives that will implement the treaty. One of the processes that was going on in parallel that never the twain shall meet was the ISACS process, which came out of the UN offices in Geneva, International Small Arms Control Standards. This is not a democratic, consensus thing. This was a few countries provided funding, and the product is exactly what those folks wanted. And some of those modules are very, very draconian in their approach. But we're already starting to see references in European fora, for example, about implementing the ATT that says you need to look at ISACS when you're drafting your national legislation. So the concern is, as that takes off, we'll start to see more and more of that, the argument that those are the international norms. So you go back and say, where did they come from? Well, they came from a small group of folks in a room, writing the legislation they thought ought to be appropriate for for these countries. I guess the last point I would make, during the process, I gained a lot of respect for the U.S. delegation. Ann, and Bill, and others, Tom, and Don Maley in particular, our senior negotiator. I mean, these are good folks that you had to kind of be there to see it. I mean, they stood up for America and for our interests. They were getting beat bloody. I mean, some of those things were going to 1 and 2 o'clock in the morning. They did a good job. They did the best they could. I thought they would, even at the last minute, they'd be overruled by a phone call from Foggy Bottom. I don't think that occurred. They did what they said they would do. They did as much as they could, but this was a negotiation, a consensus basis. You can only do so much. It's not like the Security Council where the U.S. can sometimes say this is the way it's going to be. I personally don't see a scenario where the U.S. Senate ever ratifies this thing. And I'll close with saying I think the irony there is that the same NGOs who are out there today saying anybody who thinks there are Second Amendment implications for the Arms Trade Treaty are delusional or disingenuous are the same NGOs who were there every day in the UN making sure that there was no language included in the text that would have made it very, very clear we're talking about only international transfers. It's the same folks, and I think that is the irony. Because if that language had been in there, I think it's conceivable at some point we might have seen the United States Senate ratify this treaty. Anyway, thank you.
Thank you, General. Why don't we just go in the order of the panels? No? No, okay. I'm sorry.
Yeah, it might make, yeah.
I've been overruled.
Good afternoon. I'm going to be picking up where Alan left off and focus on industry concerns over the impact the treaty is likely to have over legitimate international firearms and ammunition trade. Before I get to that, however, I do want to extend my sincere appreciation to Steve Groves and Ted Bromond and the Heritage Foundation for hosting this important discussion. We appreciate the forum and the opportunity to express our concerns over the treaty. Fair Trade Group is made up of firearms and ammunition importers and exporters who serve both the civilian and the government customers. On the civilian side, our members serve the diverse U.S. market of collectors, gun enthusiasts, target shooters, and hunters. We see imports as an essential to maintaining a vibrant domestic trade because it furthers a free and competitive market and also opens opportunities to newcomers to the sport by offering less expensive platforms, which are great for learning the necessary skills of the shooting sports. Most of the focus so far, as Alan mentioned, has been over concerns over how the treaty is going to affect the constitutional rights of Americans. And in response, treaty supporters have very quickly and eagerly dismissed Second Amendment arguments as having no basis because the treaty in the preamble references the sovereign right of any state to regulate and control conventional arms exclusively within its territory pursuant to its own legal and constitutional systems. Also, supporters are quick to point out that the treaty is not a gun grab because it is a trade treaty that will not affect the wholly domestic marketplace. But this is precisely why we are concerned, and this is what I will focus on today. As Alan has already mentioned, the treaty is creatively ambiguous. It does not clearly distinguish the general concepts of international trade from the supposed target of illegitimate or illicit trade. The consequence of this, whether intended or unintended, will be that legitimate trade and industry will bear the brunt of the norms that will develop out of the treaty, norms that, no doubt, will further restrict the ability of U.S. firms to import and export firearms. Further, it's worth emphasizing that once the U.S. signs the treaty, even if the Senate does not ratify it, the executive branch can use existing statutory authority to change policies to be consistent with standards in the treaty that it thinks are worthwhile. This is the case with the Organization of American States, otherwise known as OAS, and the Firearms Protocol to the UN Convention Against Transnational Organized Crime. As I'm sure many of you are aware, the OAS has been languishing in the Senate Foreign Relations Committee since about 1998, and the Firearms Protocol was never even signed by the President. But despite this, the administration was not stopped from adopting some of the provisions of both instruments under existing statutes. In the United States, the firearms industry is predominantly an international industry. So the comfort given to wholly domestic does not really give us a lot of comfort. To illustrate, consider the following facts. Many large firearms companies are owned by foreign entities or have foreign ownership in their structure. In addition, the supply chain in many cases originates outside the United States. So there are many technical assistance and manufacturing license agreements between U.S. firms and foreign parties that require State Department approval under the Arms Export Control Act. I'm going to be talking more about this statute later in my comments. In 2011, firearms imports comprised over half of all domestic production. So this was actually 3.1 million firearms were imported compared to roughly 6 million produced domestically in the United States. In addition, in 2011, 4.5% firearms were exported. So this was approximately 273,000 units. So as these facts illustrate, the firearms industry is hardly one that is wholly domestic. In addition, as Alan mentioned, U.S. importers and exporters of firearms and ammunition are already subject to a very complex web of laws and regulations on a daily basis. No less than 6 federal agencies have direct jurisdiction over imports and exports of firearms and other defense articles. Of these 6, I'm going to focus on State Department as well as the Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly known as ATF. Under the Arms Export Control Act and the Gun Control Act, these are the 2 primary statutes that control firearms import activities. Congress gave State Department and ATF tremendous latitude in implementing because certain key terms of art, words such as national security, foreign policy interests, and also sporting purposes, are left up to the respective agencies to interpret and define. So beginning with sporting purposes, this is the standard that exists under the Gun Control Act and which goes to the types of firearms that may be imported into the United States. The particular section states that the Attorney General shall authorize a firearm to be imported into the United States if it is one that is, quote, generally recognized as particularly suitable for or readily adaptable to sporting purposes. But what constitutes sporting purposes is not defined, so it's left up to ATF to determine how that standard is met. So it's through this undefined and amorphous language, the so-called sporting purposes test, that the President ultimately has the power to define what firearms may or may not be imported into the United States under the Gun Control Act. One example of firearms restricted from import is semi-automatic rifles with military features and the ability to accept high-capacity magazines. In addition to the import restrictions under the Gun Control Act, The Arms Export Control Act authorizes the President to control imports and exports of firearms as well as other defense articles in furtherance of world peace and the national security and foreign policy of the United States. There are several examples of how the President has used this authority to restrict what the White House has called, to restrict what firearms come into the United States. One example, which is the most recent, is what the White House has issued as the executive action to prohibit the import of any U.S. origin military-grade firearm, military grade I want to emphasize on, even if said firearm is a curio or relic. So consequently, private businesses will not be able to import for the civilian marketplace rifles such as the M1 Garand and the M1 Carbine or the 1911 A1 pistols. This is just to name a few. These firearms are very popular and sought after by collectors, historians, and enthusiasts because of their history. But now the President has summarily halted private industry from participating in this market under the guise that it will keep these surplus military weapons off our street. Despite this rhetoric, however, these firearms have no characteristics that make them inherently different from domestically manufactured firearms or commercially available firearms that are legally importable, otherwise known as sporting. The distinguishing factors, such as their collectible value and their distinction as U.S. origin material, do not, in and of themselves, make them crime guns. Another important fact is that while the President is preventing U.S. commercial importers from bringing these firearms back into the United States, the U.S. government, through the Civilian Marksmanship Program, is refurbishing these same firearms and selling them at retail value to the general public participating in competitive shooting programs. So the irony is not lost. As you can see, the agency interpretation of undefined standards flow out of policy and are therefore fluid and unpredictable. The effect on U.S. business, of course, is tremendous. Whether a company can export or import, as the case may be, will depend on how the agencies interpret these terms and standards. What is permissible today may not be permissible tomorrow. There are several examples of unannounced policy shifts that have resulted in import or export prohibitions. One example is during the 1990s, we saw wholesale elimination of certain firearms or certain sectors of the imports market, including firearms and ammunition of Chinese as well as Soviet origin. Because these policy shifts were unannounced, companies lost substantial amounts of money, and many had to even close their doors because of the financial loss they faced. So add to this reality the ATT. The treaty, as you all know, is not self-executing, and Alan mentioned this briefly. It will be up to each individual nation to figure out how to best implement it, and then how to devise laws and regulations controlling export and import activity as they see fit to comply with the treaty requirements. In light of this, it's not difficult to predict the treaty will have a greater impact on legitimate international trade, particularly U.S. industry, whose operations are already subject to strict government controls. The Obama administration has stated on several occasions that because the U.S. regulatory structure over exports and imports is the gold standard, and the level to which the ATT will bring other countries up, the U.S. will not have to change any of its laws or regulations. So this may seem like a positive point to some, but I think that it's worth close examination. As I mentioned a few moments ago, the President and his administration has enormous latitude in implementing laws like the Arms Export Control Act and the Gun Control Act. Because key terms and standards are related to imports and exports are undefined and left up to the discretion of the governing agency. So it's easy to see over time how the treaty will play an increased role in how the State Department and ATF, just to name a few of the agencies who will have this role, how they will interpret and enforce these laws. So depending on who is at the helm, the treaty could provide a convenient and effective means to crack down on the U.S. firearms industry. In addition, we've already seen instances where the administration has restricted firearms imports in the name of public safety and keeping dangerous weapons off the streets, the M1 issue. The ATT will add an additional layer to this argument so that even if the President does not have any new powers per se, he will have new justifications. So consequently, U.S. companies may find themselves having to deal with increased end-use justifications and other bureaucratic hurdles that the U.S. government implements to comply with global norms. This, coupled with the difficulty in executing business operations in light of changing U.S. policies, will force many companies out of the import or export business because it just isn't worth the headache. With every U.S. company that ceases operations, there will be a void that foreign businesses operating under less stringent regulatory regimes will gladly fill. Illegitimate operators in the black and gray markets will continue their businesses free from government interference. Likewise, businesses supported by governments who are not subject to the treaty or who do not implement the treaty to the same high standard as that of the United States will also be able to secure a greater foothold in the international market. So it's also important to note that even if the U.S. doesn't take any action at all, even if we don't sign it, U.S. exporters will still be faced with tighter rules coming from other countries who will be implementing the treaty, so it will affect them nonetheless. So the ultimate consequence of the squeeze put on legitimate international trade in firearms is that it will further restrict the domestic market here in the United States. If the market dwindles, this will have a very real impact on the ability of individuals to exercise their Second Amendment freedoms. So with that, I'm going to turn it over to David.
Thank you. The arms trade treaty is not only a threat, but will harm human rights in the United States and worldwide. Part of the problem that someone who's trying to make a fair evaluation of what's going on with the treaty, whether they are a U.S. representative or a journalist or a concerned citizen anywhere in the world, is separating the wheat from the enormous amount of chaff that's been produced by critics or skeptics of the treaty. On the one hand of the spectrum, you have the reports written by the Heritage Foundation, for example, which are careful, sober, footnoted, and accurate, and having occasionally co-authored some heritage works, go through an extremely rigorous and certainly not excessively speedy editing process, which is good for quality control. And on the other hand, to go to the far other end of the quality spectrum, you have the kinds of mass emails spewed out by an organization called the National Association of Gun Rights, which, as a native Coloradan, I'm very ashamed to say, is based in Colorado and has hysterical emails, for example, warning that Hillary Clinton was about to sign the arms trade treaty when in fact the arms trade treaty did not even exist, and it turned out that Secretary of State Clinton did not in fact sign it. While there was one treaty negotiating session going on in New York at the UN building, the National Association of Gun Rights raised more money on email by saying that the NAGR, was down at the UN fighting for your rights, when in fact there was no one from that organization within 1,000 miles of the building. And when they got caught on that, they explained how they had a more creative definition of what being at the UN meant. The arms trade treaty probably will never be ratified by the Senate, but it will be ratified by will certainly be ratified by at least 50 nations, and will go into effect 90 days after that, and will thus become part of international law. We know that even if this didn't become international law, even if the arms trade treaty had merely been a declaration of nice ideas that are popular, that would be used to harm the rights of gun owners in other nations. For example, the 2001 United Nations Program of Action on Small Arms is, by its own terms, not legally binding. It's an expression of principles and ideas, and yet the POA has been used in many countries as the pretext for local governments to crack down on law-abiding gun owners under the claim that supposedly our United Nations international law obligations require us to do that. And that's even in countries like New Zealand, which have obviously a fair and open and democratic process. International law, unlike domestic law in the United States, has less certainty to it and is more fluid and has a multiplicity of interpreters and applications. In the United States, you can often tell what the law is, and if you can't, there will be court decisions which provide, whether they're right or wrong, authoritative constructions of that. International law, partly because of the multiple sovereigns, is more multivalent, and as you've already heard, the decisive interpretations of what it actually means often don't happen in courts or other public bodies that we're used to in the United States for determining what the law is. It comes in, for example, as when the United States State Department officials are writing regulations in the Bush administration about arms exports, and they say, well, there's this SIFTA treaty, which President Clinton signed in 1998, the Organization of American States Gun Control Treaty. Clinton didn't send it to the Senate. President Bush is certainly not going to send it to the Senate. Yet we are going to require that our export control rules be conformed to the regulations that are being adopted in other places, such as by OAS models, on SIFTA. And so you have international law creeping in to effect within the United States, not through the front door of a treaty ratification, but through the back door of the practices of implementation. International law also sets moral standards. That's one of its purposes, partly because often its biggest effect is its persuasive moral value. The United Nations Declaration of Human Rights, which was created in part by my hero, Eleanor Roosevelt, our first UN ambassador, is not legally binding on its own terms, but it has had great effect in the world by moral suasion and been adopted in some nations actually as part of their constitution by reference. The Arms Trade Treaty teaches harmful lessons in its teaching effect via the morality of international law about the role of firearms in society. The preamble of the ATT declares itself to be mindful of the legitimate use of firearms for recreational, cultural, historic, and sporting activities where permitted or protected by law. And I suppose that's a nice thing for duck hunters in France, that their existence is at least acknowledged and brought to mind. But that's the only sentence in the entire treaty that recognizes any legitimacy for guns owned by anyone other than the government. And what's notably absent is the most important reason why guns are legitimately owned, not only in the United States, but as a fundamental, inalienable human right, even when not recognized by governments, all over the world, and that is resistance to tyranny. Resistance to tyranny is recognized as a human right in the International Declaration, the UN's Universal Declaration of Human Rights. Resistance to tyranny, on the one hand, includes resistance to genocidaires, like the Mugabe regime in Zimbabwe, which has very aggressively confiscated guns from its intended victims. It also includes resistance to ordinary tyrannical regimes, which is to say, create a very large number of the delegations to the United Nations. And it also includes resistance to micro-tyrants, such as rapists, lone criminals, and other oppressors. Every violent and illegitimate exercise of power over another human being is an act of tyranny. That fundamental principle of human rights was articulated in the best-selling book of the 12th century, Polycraticus. It was embraced by John of Salisbury. It was embraced by the founders of the American Republic. It's practiced by every decent person around the globe who owns a gun for self-defense. And it is anathema at the United Nations. Yet the United Nations, which is supposed to be, in its ideals, the instrument for stable and constructive international law, fails to acknowledge that international law itself is based on this principle. If you go back to the times what's called the classical period of international law, when nations really did develop laws of warfare, which they accepted as law and voluntarily obeyed, and it helped make warfare in the 1700s less brutal, with less harm to civilians than it had been previously. The intellectual arc of the development of the international law of war, from moral and legal philosophers such as Victoria, Suarez, Grotius, Puffendorf, and Vattel, all of them started their explication of the international law of war by taking the natural right of self-defense and then scaling that up, of course with the appropriate modifications of scale, to national self-defense and the individual inherent human right of armed violent defense against an aggressor, to what situations in which a nation could do that. So just as when somebody breaks into your house and attempts to kill you, rape your wife and children, and burn the place down, and you happen to be, do you have a right to kill that person? Of course. But suppose you're able to subdue them, and that person is then, you've got them tied up and ready to turn over to the authorities. Can you then take revenge on that person and kill them anyway? Well, no. And from that principle is why they say, and that's why you can't kill a prisoner of war. When you're fighting him, you can fight him. But once you've got him captured and in your power, then you don't have any right to revenge yourself upon him. And this is pervasive in the classical period of international law and the creation of the international law of war itself. The Arms Trade Treaty at its rhetorical level, and I'm sure in the hearts of some of its advocates, is intended to prevent the export of arms to places that violate human rights. And of course, that's a very important and great objective to have. But it is notable that while some of the worst human rights violators in the world, Syria, Iran, North Korea, voted against the Arms Trade Treaty, many other human rights violators at the United Nations enthusiastically supported it, with, one may infer, the idea that it won't make much difference to them. So, for example, the highly corrupt regimes in Kenya, Rwanda, and South Sudan spoke at the UN about the moral imperative for an arms trade treaty. And yet these are the very same regimes that are knowingly colluders and profiters in the smuggling of arms to warlords in the Eastern Congo, where those arms are used, of course, for massive violations of human rights. South Africa's delegation probably won the Chutzpah Award because this is a regime that is busy slowly de-democratizing the nation, suppressing internal dissent and self-defense rights as well, and is also active, complicit, directly engaged in the smuggling of arms to the genocidal Robert Mugabe regime in Zimbabwe. And this is in flagrant violation of South Africa's own laws. South Africa has very good and strong laws against the export of arms to human rights violators. And the South African government has been caught engaging in the facilitation of the transfer of arms from Asian exporters into Zimbabwe via transshipment in South Africa, in complete defiance of South African law. And yet the South African delegation at the United Nations stands up and says, oh, the ATTs, that's great, everybody ought to be for that, because that's going to require other countries to have laws about the export of arms to human rights violators, sort of just like the ones that South Africa has, which it doesn't obey. Somewhat less hypocritically, Russia and China, which are major suppliers of arms to human rights violators, were neutral on the treaty. They don't have to sign it, or they haven't signed it. There's no indication that they will or ratify it. And thus, the two volumetrically largest suppliers of arms to genocidaires and other tyrants, warlords, and international criminals will continue outside the arms trade treaty system. Dictatorships have already announced their plans to use the Arms Trade Treaty as their pretext to eradicate lawful gun ownership in their nation. The communist dictatorship in Nicaragua has announced its plans for a stringent and implacable plan to disarm citizens, and has said that the Arms Trade Treaty will be part of that plan. The same thing, of course, has been going on in Venezuela even before the Arms Trade Treaty, and the one thing we've seen is the Chavezista regimes, and of course the Sandinistas of Nicaragua were Chavezistas before Chavez himself, have learned how you can have sham elections while suppressing civil society and eradicating actual self-government of the people. It seems unlikely that the Arms Trade Treaty will be actually used to suppress arms exports to human rights violating regimes that have at least even a modicum of support at the United Nations. After all, there's no arms embargo against Zimbabwe because that regime's patrons at the United Nations are South Africa and China, and that's enough to block any action against Zimbabwe. More likely is that the ATT will be used to outlaw the supply of arms to anyone who is fighting the many dictatorships which control current UN delegations. Back from the 2001 negotiation of the Program of Action, and then in repeated program of the 2006 failed attempt to create an updated Program of Action, and on and on and on up till the present, one of the prime goals of the international gun prohibition communities has been an explicit ban on the transfer of arms to non-state actors. To the credit of President Bush in 2001, and to President Obama and the current U.S. State Department delegation in the recent treaty, that is not in the Arms Trade Treaty at present explicitly. But the treaty does come up is open for amendment 6 years from now, and there is no doubt that a ban on the transfer of arms to non-state actors will be at the top of the agenda of the gun prohibition advocates. And that would have meant, for example, that supplying arms to the Warsaw Ghetto Resistance in World War II, to groups in Iran fighting the dictatorship there, or to the American colonies fighting for national liberation from 1775 to 1783 would have been illegal under international law had this been in effect. According to the Arms Trade Treaty, governments are required to create a national control list of arms and ammunition imports and exports. They are encouraged to keep information about the make and model of the imports and the end users. With this creative ambiguity, this can be read to say, well, we sold 36 attack helicopters to the government of the Maldives on this date, and we'll report that to the UN as we already do for some arms in the existing process, and so fine. But creatively ambiguous, you can also read the encouragement for the make and model of imports and records on them, and end users to say, that means we have to have a national registry of everybody who owns a firearm, because it's the individual owner of the firearm who we define to be the end users. And then the Arms Trade Treaty encourages, but does not require, the delivery of these registries to the United Nations itself for international sharing. So if a government wants to create a gun registry and give a list of all the registered gun owners to the UN, it is entirely plausible for that government to argue that that's what the Arms Trade Treaty says they're supposed to do. As has been mentioned, the idea that the United States arms industry can exist in isolation is false, just as a matter of not only the supply chain of the fact that sometimes a particular component of an arm might be made overseas, whether it's the springs are manufactured in Mexico and then brought into the United States for assembly with the rest of the gun, but strategic metals, only the United States is self-sufficient only in molybdenum. of which Colorado is one of the great centers in the United States. Maybe that makes up for us being responsible for Dudley Brown and the National Association of Gun Rights. But titanium and chromium, the United States is not even close to self-sufficient, and you can't make modern arms. You can make firearms without them, but you can't make high-quality modern firearms without them. The Arms Trade Treaty at least gives a mid-level bureaucrat in some other nation a plausible legal argument for shutting off the export of, say, manufactured arms from that country or of arms-related components to the United States, because the Arms Trade Treaty certainly does call for and demand the cutoff of arms to human rights violators. And again, with creative ambiguity, when Americans think of human rights violators, well, we think of Syria, North Korea, Zimbabwe, China some of the time, and so forth. But when you ask the United Nations, give us a list of human rights violators, well, you look at who's been condemned for human rights violations the most. Way, way, way at the top of the list is Israel, by far the worst country in the world for human rights violations, according to official United Nations declarations and actions by its various human rights committees and others. Then you get down to so if Israel's by far the worst, there's a large gap between Israel and the entire rest of the world. But then the next cluster of the biggest human rights violators in the world, Sudan, United States, that's in the next group. So we're in silver medal contention for worst human rights violator in the world, according to the United Nations. And in regard to firearms, the United Nations Human Rights Committees, boy, they're misnamed there, have already come out with their official report, which is too polite to say, and the United States is the worst human rights violator in the world, and its standards violate human rights. But what they've said is that the report produced by their special rapporteur on guns and human rights, University of Minnesota law professor Barbara Fry, is that any country which allows the use by either law enforcement or civilians of guns to be used for self-defense except against an imminent threat to life is violating the right to life of the criminal who got shot. So if you shoot a rapist or a carjacker under circumstances in which you believe, no, this person wasn't going to kill me, he was going to rape me, he was going to take my car, or he was going to break into my house and steal all my stuff, but he wasn't going to kill me, according to the United Nations Human Rights Commission, that itself, the legal permission that every jurisdiction in the United States grants to individuals to defend themselves against rapists, carjackers, and violent home invaders, is itself a clear violation, according to the Commission, of international human rights. And so for somebody in another country who has the legal power over export licensing, they have, with the Arms Trade Treaty, as they read its creative ambiguities, a legal mandate to forbid their country from exporting arms-related materials to the United States. Within a United Nations document, and with many international law instruments in general, it's hard to tell what they're going to mean in the long run. In 1979, the UN ratified the Convention for the Elimination of All Forms of Discrimination Against Women. Nobody predicted the CEDAW was deliberately and entirely silent on abortion, which it recognized was a great divide among the delegations on that, and it said, we are absolutely not going to say anything for or against abortion. You want something, this treaty is not about the National Football League, space exploration, and abortion. And that would be the correct interpretation of anybody who was involved in CEDAW's negotiation in '79, and everyone would have agreed with that. And yet, CEDAW has been used in many national courts and elsewhere as supposed proof, and sometimes successfully, for abortion rights in other countries. And nobody predicted that CEDAW would make Mother's Day illegal, but CEDAW's Treaty Implementation Committee did tell Belarus that the way they were celebrating Mother's Day was a violation of CEDAW because their celebration of Mother's Day seemed to overemphasize the role of women as mothers rather than as professionals and participants in the workforce. The Arms Trade Treaty does not go as far in CEDAW of formally setting up a bureaucracy at the UN to announce what the treaty means. But there is to be a secretariat with a staff to be created, and one thing in common throughout the world is that little agencies and bureaucracies often start off to do little things and grow and become bigger and bigger. And certainly if the treaty secretariat at the UN just reads the biographies of J. Edgar Hoover, they will see how something that you can take over an organization that has a quite limited role and build it into a bureaucratic superpower. The hope that the Arms Trade Treaty will save lives is in a sense hoping that the UN's record on would be more plausible if the UN had a good record on saving lives and you said, well, they've done a good job so far and we want to make them more powerful so they can accomplish more. But the record of UN arms control is deadly. It was UN arms controls that facilitated the Rwanda genocide in 1994. It was UN arms controls that facilitated the mass murders of the Bosnians in Srebrenica in the former Yugoslavia. Whether or not the U.S. Senate ever ratifies the Arms Trade Treaty, it will be used in many places of the world to crack down on lawful gun ownership, and thus leaving the United States with its robust culture of gun ownership increasingly isolated in the world. And isolationists may say, so what? But global norms and global practices do fit in and ultimately affect the United States. Think of how much in the past half century, where we've had this great national debate on gun control, of how much influence the more repressive laws in Europe have had. Now, not that Americans who are in favor of gun control in the United States necessarily have a precise idea about how the laws in France are different from the Netherlands or different from England or different from Finland, but they know that Europe, and this is accurate, is that in Europe on the whole, it's much more restrictive than in the United States. Imagine that instead, if European gun controls were about as strict as the median American state, say Nebraska, or say for that matter Illinois as it currently exists, where you have to get a license that sometimes is supposed to take a few weeks and often takes months, but then you can buy pretty much whatever gun you want and you can have a permit to carry a gun for protection. If Europe were like that, there would be a lot less pressure for gun control in the United States. So the Arms Trade Treaty will aggravate the existing pressures against American gun ownership and the Second Amendment, regardless of whether it is ever ratified by the U.S. Senate. Thank you.
Thanks very much, Dave. I'd like to wrap up with a few concluding comments, collecting a number of observations about the treaty, primarily in its international context. First, I want to thank all the panelists, as well as Steve Groves, for his work in hosting the panel today. As all the panelists have argued, the ATT is not the kind of thing that you sign and then you're done with. In my view, it's not an event, it's a process. We've already heard several of the panelists talk about the problem of the administration's red line. I don't want to pile on to that. I simply want to add a quote in a speech delivered on behalf of Undersecretary Tauscher on February 18, 2010. The administration doubled down on its own red line, stating that, quote, not getting a universal agreement would make any agreement less than useless, unquote. Well, today the Arms Trade Treaty lacks the support not just of Iran, Syria, and North Korea, the nations that broke its consensus at the UN. It lacks the support of major players like China, Russia, Indonesia, and India. I agree with the administration. The ATT today is, quote, less than useless. This was not the only way the administration shifted its position. It's not the only way that you can see that the Arms Trade Treaty is really a process, not an event. In 2010, as Acting Deputy Assistant Secretary N. Ganser put it, and thank you very much for being here today, the U.S. wanted an ATT that covered, quote, all conventional weapons from military small arms and light weapons up. But the U.S. did not secure the Arms Trade Treaty that Director Ganser, as she now is, called for. Instead of an ATT covering, quote, military small arms, the ATT covers simply small arms and light weapons. The U.S. did not get its civilian exclusion. So the U.S. gave a lot of ground in the ATT negotiations. I want to join General Youngman in saying that I don't blame the U.S. delegation led by Assistant Secretary Tom Countryman for this. I had the pleasure, and it was a pleasure, of watching the public side of the negotiations, and I have a very high respect for the professionalism and patriotism of the team that he led. The problem was not our diplomats. The problem was that if you set out to negotiate a treaty on the conventional arms trade with the entire world, you're going to have to take, ultimately, what you get. A precise, carefully defined treaty that included everyone would take forever to negotiate, and, by the way, a precise, carefully defined treaty probably wouldn't be very satisfactory to the United States. So when Assistant Secretary Countryman describes the ATT as ambiguous, as we've already heard he's done, he's correct. The Arms Trade Treaty defines none of its own terms, and that was our negotiating strategy. It's also the problem. Now, the U.S. was pulled away from some of its red lines by the process of negotiation, and in the future, my concern is that the U.S. will be pressured to reinterpret the Arms Trade Treaty as the treaty's ambiguous terms are defined and redefined. And it's not just a case of pressure. Some U.S. policymakers will, I fear, welcome the opportunity to import new norms into the U.S. system. In short, in my view, the ATT is a conveyor belt. Once the U.S. steps onto it, we are not in charge of where we are going. We are binding ourselves to uphold a treaty that we are not solely in charge of interpreting. Now, at the heart of this problem are the standards that sit at the heart of the final treaty text. Collectively, three of them are particularly troubling and important. There is the requirement for a knowledge-based assessment of arms exports in Article 6.3, and the requirement in Article 7.1 that arms exports should be assessed for their potential to, quote, commit or facilitate a serious violation of international humanitarian or human rights law. Now, the problem with the knowledge standard is that it's really a know or should have known standard. It opens up the U.S. export control process to endless second guessing, conducted through the UN or by the pro-treaty NGOs, which in turn will change the way the U.S. process operates. The humanitarian and human rights standards, commonly known as IHL and IHRL standards, are even worse. International humanitarian law used to be known as the laws of war, and under that guise, it does deserve respect. But IHL has become a way to wage lawfare against the United States and nations like Israel. For example, the notorious Goldstone report accused Israel of committing, quote, crimes against humanity in the course of the 2008-2009 Gaza war. IHRL, the human rights standards, are even more ill-defined. By accepting them, the U.S. will be held by other signatories and the NGOs to have agreed to a set of evolving norms that it is not solely responsible for defining. I think it's important to recognize that leading liberal commentators admit this proudly. For example, John Eikenberry of Princeton, a very eminent scholar in international affairs, argues that, quote, the international community is the repository for new human rights and national security norms, unquote. In other words, the UN and the international community are asserted to have the power to define and to redefine what is meant by the IHRL standards that are at the heart of the treaty. U.S. policy at the highest level is already being shaped by considerations like these. In mid-July, the Wall Street Journal reported that the U.S. decision to aid the Syrian rebels had been held up by, quote, a string of cautionary opinions from administration lawyers, who concluded that such aid was not clearly permissible under international law. Now, regardless of whether arming the rebels in Syria is a good idea or not, U.S. policy is already being shaped by those who cite what the Wall Street Journal described as, quote, the risks of skirting international law. In the future, the ATT will be yet another international legal barrier to action that policymakers will have to surmount. It's important to remember that the adoption of the ATT was driven by NGO advocacy. led most prominently by Oxfam and Amnesty International. These NGOs approach treaties not as diplomats, but as late-night TV marketeers hawking a miraculous product. I collected this little souvenir on the final day of the last Arms Trade Treaty Conference. It's a gingerbread cookie baked in the shape of a bullet. Perhaps by itself not terribly persuasive, but it demonstrates that the NGOs behind this treaty have a range of imaginative marketing appeals which the diplomats who actually negotiate the treaty and skeptics like myself frankly can't match. These people are extraordinarily clever, and I admire their energy and their ingenuity in shaping and driving the public debate. That's a very significant matter. The NGO mentality, in short, combines intense credulity and fervent belief, and it will continue to drive the arms trade treaty process, including the interpretation of the standards at the heart of the treaty. Governments and companies that don't understand this are making a grave mistake. Now, U.S. officials assert that the Arms Trade Treaty will not change U.S. foreign policy or its export control system. That is not what the NGOs say. For example, Scott Stedgen, then Senior Policy Advisor at Oxfam America, stated in June to the American Society of International Law that, quote, "I believe the treaty goes further than what the U.S. currently does and what it says. And over time, by virtue of the treaty being a global norm that stigmatizes certain types of arms transfers, it will have an effect on U.S. practice. And this group knows this very well." Couldn't have said it better myself. That is what the NGOs expect, and that is what the NGOs want. They want a treaty that establishes evolving global norms, and in so doing advances the policies they prefer. Unfortunately, the NGOs are relentlessly credulous about the power of treaties, and they rarely concern themselves with the problems of treaty enforcement in the world's incompetent or autocratic states. Practically speaking, they focus on the United States and they give the dictatorships a pass. The pro-treaty NGOs are also profoundly skeptical of U.S. foreign and security policy. They are already arguing that the ATT makes arming any rebel group anywhere, quote, arguably unlawful. They strongly dislike the predominance of the U.S. in the international arms trade. Many of them are deeply skeptical of Israel, which much of the NGO community, as Dave has pointed out, has long caricatured as an egregious human rights abuser. They see the spread of the treaty's norms as a partial solution to all of these supposed problems. Among both supporters and critics of the ATT, there is under the surface widespread agreement that the treaty is about creating global norms. There is equally widespread agreement that these norms are, in part, about changing U.S. policy and process. No less an authority than Harold Koh, the State Department's own legal advisor during President Obama's first term, has noted that, quote, "Make no mistake, this is not your grandfather's international law. 21st century international lawmaking has become a swirling interactive process whereby norms get uploaded from one country into the international system and then downloaded elsewhere into another country's laws or even a private actor's internal rules." I should note first that Koh approves of this. I might also note that Koh believes that, quote, "the only meaningful mechanism to regulate illicit international arms transfers is stronger domestic regulation," unquote. Those who dislike the idea of the U.S. downloading gun control norms from other nations will not agree with him. Nor will those who are worried about the ATT's effects on U.S. industry. The risk there lies just as much in industry-level codes of conduct and voluntary agreements as it does in new regulations per se. As Koh notes, norm-based institutions like the ATT work by changing internal rules and by creating opportunities for public pressure, not merely or even primarily by altering formal legal structures. Throughout the ATT process, U.S. industry has been concerned about the ATT's potential effects on export control reform. In my view, the assurances that U.S. industry has received are worthless, because as the standards at the heart of the treaty evolve under NGO pressure, so will the way the U.S. makes its export licensing decisions. Industry has by and large not recognized that the ATT is a process, not an event. Nor, of course, can U.S. promises made today protect against boycotts and third-party discrimination by foreign signatories tomorrow. Norms do matter. For those who believe they don't, I refer you to the words of President Obama, who, in seeking to make the case for U.S. strikes on Syria, asserted that they were necessary or even required to respond to a breach of a, quote, international norm. It says a lot about the peculiar power of the norms argument in the United States that almost no other nation in the world appears to have agreed with him. In my view, this kind of norms talk is both very silly and extremely dangerous, because as I've noted, it's not about changing the words of the Constitution, it's not about changing the words of our laws, or even the wording of our rules. It's about changing the way we interpret the words on the page. It's fundamentally an attack on U.S. sovereignty, and it is intended as such. And there is a final concern. The ATT does not stand alone. As General Youngman has noted, it's one of a wearying number of UN institutions, all of which revolve around small arms regulation and control. There's the UN Program of Action on Small Arms. There's ISACS, the UN's International Small Arms Control Standards, and there is much more besides. Over the coming years, my concern is that we will see an incremental interpretive convergence of all these institutions. This will happen partly through the ATT's amendment process, which is a majority rule one, but also partly because these other UN institutions we treated as new norms that the ATT automatically incorporates. For example, the 2013 annual report of the UN Institute for Disarmament Research notes that ISACS, the Small Arms Control Standards, will become, quote, the normative basis for assessment, evaluation, and reporting on national efforts to control small arms and light weapons. Or take the Secretary General's 2013 report on small arms, which claims that, quote, given their synergistic relationship, the ATT is expected to lend strong impetus to the implementation of the program of action. It's very difficult to untangle all of these UN institutions, and those behind them have no interest whatsoever in doing the untangling. Panelists today have noted the number of risks inherent in the U.S. signature of the ATT. I would close by emphasizing a couple of points. First, the U.S. holds itself bound not to violate the object and purpose of a signed but unratified treaty. This is particularly problematic in the case of the ATT because the vague and evolving norms at the heart of the ATT can, as several panelists have noted, be enforced entirely by executive branch actions. Second, we are regularly told that the ATT cannot and will not require any changes in the way the U.S. arms export control process works. This is basically a trust me argument. We've already seen how the U.S. failed to achieve a number of its central objectives in negotiating the ATT, which largely, I suspect, because we didn't want to look like the bad guy. That same dynamic will continue to play out as the ATT is amended and its norms are reinterpreted and applied in practice. So to those who say, trust me, I ask why trust tomorrow will turn out any better than trust yesterday. The ATT makes about as much sense to me as trying to solve the problem of crime by passing a law against it. The problems at which the ATT are nominally directed are caused by the incompetent and dictatorial regimes in the world. By falling for the line that the answer to these problems is a treaty, we are creating an institution that will certainly bind us in ways that we can neither control nor predict. Thanks very much.
I'll quickly take the moderator's privilege to get the discussion going and then open up to the floor for some Q&A. Ted, you stole a little bit of my thunder by talking about the international norm thing. I had this question, all this question teed up. We'd heard a lot about international norms in the last couple of weeks from the president that our proposed military strikes into Syria are justified by an international norm because Syria is not a party to the Chemical Weapons Convention, so they're not obligated by a treaty obligation, unless you go back to that League of Nations treaty, not to stockpile or use chemical weapons. But because 98% of the world's population live in a country where the CWC is in power, there is some floating international norm out there that justifies the use of U.S. military force. So my question to the panel is that what you're driving at here? That I've heard several people say that there's no chance that the Senate's going to give its consent to ratification, but the treaty is going to exist, these standards that are going to be adopted by ISACs are going to exist, and there's already example of our regulators adopting regulations based on SIFTA, although we're not a party to that gun control treaty. Is that what you think is going to happen in the long run when we do not ratify the ATT?
Well, maybe I can take the first crack at that. The Chemical Weapons Convention example is interesting for a couple of reasons. First, Syria may or may not be in breach of the CWC. We certainly are. So is Russia, for that matter. So, you know, there's an interesting argument right there. Second, if you go to the CWC, you'll see, I think it's article number 2, the CWC almost begins with a very careful, precise definition of all the terms contained in the CWC. I challenge people to go to the Arms Trade Treaty and look for the section labeled definitions. Well, it's not there. As I hinted in my remarks, this is one of the things I find slightly disconcerting about this treaty. It doesn't define any of its terms. I would say that chemical weapons are not the absolute high end of, you know, the WMD spectrum. Obviously, nuclear weapons and probably even biological weapons are more serious, but obviously they are viewed with more horror, and they can cause more potential damage at one go than, say, you know, an individual firearm. The concern I have is that firearms are regulated in this country in ways that are incalculably more complex, more thorough, and more far-reaching than the kinds of regulations and compliance that exists for something like the Chemical Weapons Convention, you know, which, as I've already noted, we're not in fact in compliance with ourselves. So, although the process that you're alluding to of sort of global norm advancement, I think, is similar, the way those norms can work in the United States because of the complexity of our internal regulation is far more serious and far more difficult to sort of put a finger on because of the opportunities for administrative finagling.
And just to build on what Ted just said, I think part of what we're worried about, I mean, this is a treaty that is unique. It's the first of its kind. So we don't really know how things are going to shape in the future. But looking just in the way things have developed in the United States, recently I think it's fair to assume that the treaty will be used as a basis for increasing controls on industry. And again, you know, citing back to my M1 example, the executive action that just came out a couple of weeks ago is a prime example of that. You know, I think that in touching on what David mentioned during his presentation about how the U.S. is seen already as a violator of human rights because it permits its citizens to arm itself, you can see how that will just very naturally start putting pressure on the U.S. government to put increasing controls on what it allows to import and what it allows to export. So I think while some may argue we're being highly speculative, I think it's fair to assume, based on history and what we've experienced in the past, that it's a pretty fair assessment of what's to come down the pike.
You can go back to Legal Advisor Coe's confirmation hearings in the Senate when Foreign Relations Committee, where he gets a question like, well, do you think that international law overrides the Second Amendment? And he said, of course not. The Constitution is the supreme law of the land, and that's the level at which the senators had the ability to ask the question, and he hit it out of the park pretty readily. But what the follow-up is if you read Professor Coe's scholarship as I have, and he's, of course, an outstanding scholar and an excellent writer, is that you interpret constitutional provisions and every other part of law, he argues, in accordance, in compliance with international law, so that there's not a conflict between them. And so what does the Second Amendment mean? Well, he would urge, and he has a great many followers intellectually, including the ranks of our federal judges and a minority on the current Supreme Court in accordance with his position, that whatever the Second Amendment means is not simply a matter, or other parts of the First Amendment too, quite significantly, is not simply a matter of, well, what's the original public meaning and that kind of things, and what are the U.S. Supreme Court and other U.S. judicial precedents on that, and the sources we're used to looking at. It's that you also take into account what does international law say about this, not as something that binds the rule of decision, but something that influences the way the decision should go. Similarly to how the Supreme Court's jurisprudence on death penalty for, say, 17-year-old murderers has not said, oh, we have to do it this way because that's what the European Union does, but it looks to what the European Union does, to the African Convention on the Rights of the Child, which I'm fairly sure is not legally binding in the United States, and to other international instruments and norms about how those instruments have been interpreted to tell us what the law is in the United States. And again, this is the key point. It's not changing the words of the law, it's changing the interpretation of the law. And this is by far the most important and dangerous feature of how international law works in general. And by the way, if you back to the text of the law, I've not read the Chemical Weapons Convention Treaty recently, but I don't think it applies to countries that haven't signed it. And B, I believe the mechanism for a violation of the Chemical Weapons Convention is you're supposed to bring a complaint to the International Court of Justice in The Hague, rather than having, or the Security Council, rather than having one global leader decide to launch an unbelievably small, violent attack on another country, which isn't a signatory in the first place, and say, oh, by the way, bombing this other country, that's not an act of war. The United States had a different attitude about that in Pearl Harbor. We did not take the position that just because there were no Japanese boots on the ground in Hawaii, it wasn't an act of war to bomb us.
I guess I would sort of add on to that by saying that there's a lot of discussion of the AGT as a gun grab, which, as Dave sort of hinted, I think is a very foolish way to discuss this treaty. What I'm concerned about is not gun grabs. What I'm concerned about is the slow exertion of administrative and bureaucratic pressure. That's in the way the United States works, that's a far, far more plausible thing to be concerned about. And by the way, a much tougher thing to keep your hands on and to control and to resist.
Yeah, it's constriction, not grabbing. The blue helmets will not be showing up like the redcoats at Lexington in 1775, but they'll be slowly choking off the air.
But there may be another federal form to fill out.
Yes.
Yeah.
And under the radar, too. It doesn't get the same kind of attention. It's not as sexy.
If I understood your question, Steve, I think there's two levels that we need to address. One is the way other countries interpret and implement the treaty and the impact that has on international norms. To the extent that those norms are uploaded, as has been mentioned earlier, we need to be concerned about how they're downloaded in this country. I think there are two opportunities to shape that if the administration wants to take advantage of them. And I think there are a number of reasons why they should do so, and it's either through a presidential signing statement that makes it very, very clear, just go back and cut and paste from our red lines, that this does not apply to anything domestic, it is only about international transfers, because that is not explicit in the treaty. I think that'd be a very reasonable position for the president and his advisors to take. And I think that would limit application in the future of international norms in a domestic sense to be used as justification for doing various things in this country in the name of compliance with the treaty.
And I would just add one final note on what you were mentioning, Professor Kopel, that the Roper v. Simmons case that outlawed the juvenile death penalty as unconstitutional, part of what one of the justices relied upon in reaching that conclusion was pointing to a treaty, the Convention on the Rights of the Child, that the U.S. is not a party to. So how far of a stretch is it in deciding a Second Amendment case for one of these minority folks on the court to point to an arms trade treaty to which the U.S. is not a party? I don't think that's too much of a stretch.
Well, and there's actually there will be a signature on that, which puts it ahead of some other things that the courts have relied on.
I'd like to turn it over to the audience. I do have another moderator's question, but I'm imagining we're probably running short on time. If there are any questions from the audience, please wait until the microphone reaches you so that folks watching online and on our tape version will be able to hear your question. Do we have any questions from the audience? You have one down in front?
Baker Spring with the Heritage Foundation, a little bit outside my area of expertise, although I've focused on the international aspects of this. It seemed at the outset that there is sort of a consensus among the panel is that U.S. regulatory authorities, and I mean that both at the federal and state levels, have much broader flexibility in terms of applying things than may be appropriate. If there is a debate over this treaty, is there an opportunity therefore, at least at the federal level with Congress, putting in some more well thought out restrictions on where the regulators can go?
Do you mean in terms of amendments to the treaty text itself, or?
No, I mean just in terms of.
In terms of like the Arms Export Control Act or the.
What I have in mind here is that if there's an anticipation for a debate on the treaty here, and people who are concerned about gun rights in this country think that the regulators are themselves rather unguided by statutory law, that Congress could intervene even before there would be a debate on this kind of thing to essentially limit the scope of what the regulators may engage in.
I think realistically, the only pathway would be to address either the Arms Export Control Act or the Gun Control Act. And I don't want to seem like an eternal pessimist, but I think that it would be very difficult to make any significant changes in that regard.
I think that some of the dilemma as a society will face is if the president elects not to issue a signing statement, saying this is what the treaty means in this country. The next opportunity would be as a transmittal process to the Senate, where you can develop RUDs, reservations, understandings, and declarations, which could say what in fact this treaty means. Given the history of SIFTA, 1998, as Dave said, been sitting there, gathering dust somewhere in the basement of the Senate, likely unable to ever be brought for debate. I don't know that anybody really wants to have that debate in the Senate. So the treaty will be transmitted, but I don't think that's really going to be much of a forum for airing some of these concerns about how the treaty is applied in a regulatory sense.
The treaty, to the credit of the negotiators, explicitly allows that countries which ratify it can make reservations to the treaty, but it also says that they can make whatever reservations you want, except they don't count if they're contrary to the objects and purpose of the treaty. And, well, and who's going to decide that? But it's certainly, even that itself gives, if we have let's imagine we're ratified in 2016, in 2027, a State Department person could say, yeah, but these reservations you put in, I think they're contrary to the object and purpose of the treaty, so we're going to treat them, these reservations, as if they don't exist because they're inherently void.
Do we have any other questions from the audience? There's a gentleman here.
Hi, Chris Cooper. So I've heard a few people say here already that this treaty in itself, even if not passed by the Senate, still has consequences externally coming from countries that want to put pressures on us or may not want to trade with us any longer. I think Ms. Reeves made a point as well, is that a lot of firearms in particular are made from parts that come outside of our country. So we're looking at possible threats in that regard as well. We live in a global economy, so that's a big part of our arms trade. I've also heard that this is potential for a national registry to be shared with the UN or any other entities as well for unknown reasons or for reasons that we could extrapolate on. I've also heard that some solutions to this in particular, like let's say amending the Gun Control Act or whatever else, would be nice, but most people here know that's an upward battle that not many congressmen or senators understand or want to get into in the first place. So essentially what I'm being told here is that this is bad, it's incrementalism, like everything else has been in the past, there's nothing you can do, essentially. Now, I'm willing and open to the idea that there is something that we can do and that you guys have ideas as well. But there needs to be, I think, at some point, an area in which there becomes a groundswell within constituencies, within people, understanding this on a maybe not such an academic level, of looking at things that are a little bit easier to grab, and how do we utilize that, how do we mobilize that, and even if we did, would it work? That's really my question.
Well, I mean, this is a conservative foundation, so maybe a touch of pessimism is not totally unwarranted. But I don't want to seem like it's all doom and gloom. My first answer to that question, and I recognize this opinion is probably not going to be accepted, is don't sign the treaty. Don't put yourself in that position of either having obligated yourself to fulfill obligations that cannot be precisely defined, or else sign and then, don't actually fulfill them, which is not a course I recommend for the United States with any treaty. If we're going to sign it and potentially at some point ratify it, we should actually carry it out. A fairly simple position. So start off by not signing. I recognize the truth of General Youngman's comment at the very opening that the U.S. was in an extremely difficult position in 2007, 2008, 2009. Once the process for a bad treaty gets really rolling, the U.S. is faced with what is almost a no-win situation. We can jump on board and try to mitigate the damage, but it is a process of damage mitigation. It's not a cure. You just try to prevent disease from getting any worse. So my recommendation sort of over the whole scope of a treaty's life is, I think we need to be more proactive in trying to shut down bad treaty ideas before they pick up enough momentum that we're faced with the Hobson's choice of saying no and looking like global norms violators, or jumping on board and mitigating the damage. I think we can't stop every bad thing that comes down the pike. But the role of NGOs in today's diplomacy makes it all the more important that we try to get out ahead of this process. So it's a little late in the game, I acknowledge, for that on the Arms Trade Treaty side. But I would start off my recommendations with don't sign. Maybe others have other ideas.
Go ahead.
If I can be slightly optimistic here, and that is, in my world, there's not a lot of people who realize how many laws are involved, how complex those laws are, and how much power Congress has given to the executive branch in interpreting those laws. Like I said, it's these key terms, these standards that are undefined, so it's left up to agencies like State Department and ETF to determine those standards. So if nothing else, I mean, if at the end of the day today, if more people are aware of those challenges that industry faces, and that awareness leads to more vocal discussions, it's redundant, but discussions with the lawmakers on these existing laws, and especially in light of how international law now is being brought into the fold, and probably will continue to be down the road, then maybe that will open up the chance to change some of the laws that we already have, make them more precise, possibly. Another thing that I want to mention in terms of the export control reform effort that's going on, firearms and ammunition has been put on the sidelines, and I think that is probably indefinite. So it will, as far as I can tell, at least in the immediate future and probably long term, while all this other effort is going forward and reforming export controls, firearms and ammunition, the administration is quite fine with leaving it where it is. So, that's another key thing that, not so many people are aware of.
It would not be surprising that in the 2016 presidential campaign, some candidates will say, sure, everybody gives you platitudes about the Second Amendment, but here's one of the things I'm going to do in my first month as president is something concrete, which will be to withdraw the U.S. signature from the treaty. And that candidate, and Harold Coe would have persuasive, respectable arguments about why you can't unsign a treaty, but President Bush unsigned the International Criminal Court Treaty, and some presidential candidates might promise to do that for the Arms Trade Treaty, and it is possible that one of those candidates might be elected and might keep the promise. Which again doesn't come close to solving the entire problem, because as I've argued, the harm that it does to law-abiding gun owners in other nations does have a profound long-term harm on law-abiding American gun owners.
I think the incrementalism you mentioned is the real grounds for concern. Not just in the treaty as it stands today, but Ted touched briefly on the amendment process, and circle back to that for a minute. the great work that the U.S. delegation did in keeping the really bad stuff out of the treaty simply means that stuff will come back in the first wave of amendments. The amendment, as long as the amendment process was, as it was emerging through the drafting of the text, thought to be, it would also be a consensus requirement. Some of us had an internal debate. Does that mean that the U.S. then needs to ratify the treaty so we're present at the Conference of State Parties to consider amendments? Only parties to the treaty are going to be allowed to even attend, much less have a vote there. So the issue is going to be somewhere down the road. Are we better off being a party to the treaty with an interpretation by the president says we're already in full compliance, no further action required, and then send these same folks back to the Indonesian lounge at the UN building for midnight sessions to say, no, the stuff that was stupid back in 2013 is still stupid, we're not letting it in through the amendment process. But now that it's only a 3/4 requirement, that means even if the U.S. is a party, we can't stop the amendment process. So I think the incrementalism you mentioned is a very valid fear. I think it's going to continue to get worse.
Yeah, just a two-finger addition to Ted's answer. Once this ball gets rolling, in this modern treaty process that we're kind of stuck with, the NGOs come up with this idea. They get the ball rolling. They get enough European nations on board to get the treaty process rolling. And the United States is in that position. Are we going to be inside of the room trying to do damage control on this, or are we just going to boycott the entire operation? Now, the reason that they were able to get in and say, okay, we're going to get on the inside and try to shape this thing is because they had a trump card, which was their red line, which was no treaty will be agreed to unless everyone agrees to it. This is going to be consensus. This is our red line, and we won't break it. But we have seen the value of this administration's red lines, and how are future administrations going to negotiate treaties when they lay out their negotiating red lines, and who's to believe them if they're going to be so easily crossed and without any consequences? And so now we're stuck with a UN General Assembly treaty that we are almost certainly going to sign. And once that is signed, and if and when it does get transmitted to the Senate, I'm sure that we can all come back here and have another panel discussion at Heritage as the debate has hearings in the Senate, and we'll see where we go forward from there. But for now, I thank all of you for coming and spending time with us here at the Heritage Foundation. Please join me in showing some appreciation a final time to our panel.